It was that. All right, are you Mark Anthony King? And so Mr. King is charged in cause number 25, DCCR 1063, 1064, and 1065 with aggravated sexual assault of a child. The bonds, it looks like, are they all set at $250,000? The bonds are currently all set at $250,000. Ms. Holmes has filed a motion asking for me to reduce those bonds. And just based on what you guys were just saying, it looks like offense dates were from 2018 and 2019. Mr. King was a juvenile at the time and has now been certified. When I say at the time of the offense as a juvenile, but certified to stand trial as an adult at this point, correct? Yes. We're all on the same page. Okay. Yes. Mr. Nichols, before we go too much into it, what is the state's position with regard to bond?
I don't have a huge objection to a reasonable bond, Your Honor. This case involves allegations with an 8-year-old girl, or 8-year-old at the time. It was a delayed discovery, delayed outcry. In all candor, I've had trouble getting in touch with her family. And so I don't know where this case is going to end up at this point.
Was there, what was the relationship with the alleged? A cousin, okay. So, Mr. King, where will you be living if you make bond in your case?
With my sister.
With your sister? And what do you know the address?
1489.
Is it Beaumont? Is it Port Arthur? Is she here?
No, I talked to his mom.
It's in Beaumont.
It's in Beaumont. What's your sister's name?
Raven Wilson.
Raven Wilson? Okay. Does Raven have children? How many?
Five.
How old?
Bond reduction possible, but NO kids allowed. Judge draws a hard line.
That's going to be a problem.
You can't stay with your mom?
So here's the thing, based on the nature of these allegations, at least while your case is pending, if I reduce those bonds, you're not going to be around any children under the age of 18. So do you have another option of where to live? You'll have to ask your mom. Okay, so let's do this. I'm not opposed to reducing the bonds, but I need to know that there is a place where there are no children under the age of 18 with someone who's willing to make sure kind of that happens. We don't need to have a hearing necessarily. I'll make the conditions of that. I'll likely have a GPS monitoring device and understand that that's a financial issue. So I'll take that into consideration on the amounts and also what Mr. Nichols said about the complaining witness and some difficulty.
And we'll continue to do our job, Judge. It's just at this point we haven't been able to make contact.
Okay. And is it the same complaining witness in all three?
There's 2 complaining witnesses in the three cases.
Okay. All right. And are they the same?
Same rough age.
Family.
Yeah, 2 of them
But
is the same person, they just had 2 different dates.
But the two complaining witnesses, what is their relationship to each other?
They are cousins.
They're also cousins.
Yes.
Everybody's cousins. Okay. All right. So, yeah, get me that information. If you'll just send an email, Ms. Holmes, to Mr. Nichols and I'll let y'all know together what the amount is and what the conditions are, as long as there's a place that is for sure with no children under the age of 18. Okay.
Thank you, Your Honor.
Thank you. Keep those. Oh, is Joel coming? Oh, yeah, that's right. All right, so you're Romeo Johnson.
Yes, ma'am.
And Mr. Johnson's cases are set for trial to begin with jury selection next Monday. Was the announcement?
We're ready, Your Honor. Case ready for trial. Judge provided how the court rules on a certain issue, and that issue being we're going forward, or the state desires to go forward on the unlawful possession of firearm by felon. We have literally just 2 pieces of evidence for that trial, no witness testimony. The evidence, one of the pieces of evidence we want to introduce is a surveillance video that was introduced during the murder trial. The court will recall that this defendant was found not guilty in, and that the surveillance video shows what appears to be the defendant in possession of a firearm. The sponsoring witness of that video is out of the country. It will be out of the country for a month. Under Rule 804 of the Texas Rules of Evidence, I believe the state can use the prior testimony of that sponsoring witness because it was subject to cross-examination by defense counsel. We have secured a transcript of that witness's testimony. We provide a copy of that transcript to Mr. Wilkerson, and if the court will allow us to use that transcript, then there's no need for a continuance, and we'd be ready to proceed with trial.
Your Honor, I didn't come prepared to argue that. This is the first I'm learning of that unavailability, unless Mr. Coleman sent me something yesterday.
I don't see anything. There was I guess, just recently filed a notice of intent to introduce transcribed testimony.
I did file that, Judge, with regard to not only the surveillance video, but also with regard to the defendant's own testimony as well. The court will recall you took the stand and essentially admitted to possessing a firearm that day.
Which murder trial was that? Remind me what I'm.
Romeo Johnson murder trial. It was. The complaint was the victim was one of the twin brothers, Ronald Barnes.
Yeah.
I can't remember the other
Yeah.
brother. You recall the brother was in the wheelchair that testified on behalf. With regard to this,
Give me just a second.
Ronald and Donald Barnes.
Yeah.
And Judge, I know you're reading, but Mr. Freeze or Judge Freeze did tell me to let you know we're in a 2-day trial.
No. Take me just a second.
Yes, Your Honor.
I don't know that this would.
My interpretation.
I mean, under 5, so 804A5.
804B, I think is what I'm.
Well, first is A is the criteria for being unavailable.
Sure.
So a declarant's considered to be unavailable if. So you've got to get one of those 5 to be unavailable. Then you go to B. So it's not 1, 2, 3, or 4. So 5 would be the only one possibly. It states that is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure the declarant's attendance or testimony.
And that is what we're hanging our hat on, Judge. My investigator, Mr. Bass, is here to testify on the efforts that the state has endeavored in to secure the presence of the sponsor.
Okay.
And I represent to the court that we've been unable, despite our best efforts, to secure the presence of evidence, given the fact that he's out of country.
And so, all right, so if we're gonna get into that, we'll wait and do it at another time. I'll either lunch or like tomorrow morning or something.
Yes.
Because I need to this is probably, we're down to maybe 2 cases. So I will need to make that decision and number the cases. So let's do this, because I would need to hear that information. I think I want to look up a little case law just to make sure. And so you've got one witness?
No witness at all, Judge.
No, one witness that's unavailable.
Yes.
And that witness would be sponsor.
The surveillance video that purportedly shows the defendant possessing the firearm.
And then
And the other piece of evidence would be the defendant's own testimony. For planning purposes, Judge, I suspect this trial, at least the state's portion of the trial.
I just feel like without reading that, and I've never had this come up, where in his own trial, introducing testimony seems to violate the Fifth Amendment to me.
I don't follow this.
Well, I mean, it's almost like you're forcing him to testify
It's a
by
prior-
putting on prior. I don't know. Let me look into
It's a prior
that.
statement by party opponent, Judge. I mean, he's admitted from the stand under.
I just need to do some research that if it's I know if it's another party potentially, it talks about when it's a criminal case,
Key witness out of the country trial now hangs on one legal rule.
what's given as a witness at a trial or hearing of the current or a different proceeding and is now offered against a party.
I mean, he very well could have asserted his Fifth Amendment right during that trial, and he did not, Judge.
Okay, let me look into that. You look into that as well. So
Yes,
804, it looks like we've got two things. One is under A with regard to the unavailable
Yes, Your Honor.
witness. The other is under B, which is the former testimony of your client. So let's, I'll give you an opportunity. About how long do you think you guys will be going?
We anticipate finishing this afternoon, Judge. I could come back on the lunch break, or,
No. You're in the middle of a trial. I don't want you to have to think about this and do that. I will number the cases tomorrow morning. So let's take care of this. Are you available to come? It won't take long. That gives me some time this afternoon to also do a little research.
I've got another case in the 317th, oddly enough, but, I think I can kind of delay that.
If you can come
case
here
to-
first.
Yes, Your Honor.
It won't take us longer than, it'll take 15 minutes. I mean, there's really, I'm assuming your investigator, it will be quick to testimony as to the unavailability. The other is just legal issues that we all need to just look into.
I'll ask for a trade out since I couldn't stay
Perfect.
here today.
All right, so head back down there. We'll get you back over here tomorrow morning, 9 o'clock.
All right, thank you,
Okay,
Judge.
sounds good. And if everybody gets here a little early, we can start early. I'll try to be here early as well. All right, go back with the bailiff. We'll see you tomorrow.
Come back tomorrow.
Yes, sir, you'll come back tomorrow, and that way we know what's going on for sure if you're going to trial or not. Yes, sir. Why has it not been indicted?
The alleged offense date was what, December 5th? It's recent. So maybe that's why with closures and
I'll make a
holidays.
phone call and check with the detective this morning, Judge.
Okay. Am I thinking of a different one? Is this the one where the victim and the,
This is the one
Aggravated.
we started with the sexual assault trial and we got through and we couldn't get the victim to come back. There was a plea deal entered on the aggravated assault and a dismissal on that sexual assault.
okay, this is a different one that I'm thinking of. As far as, I was thinking another murder. Okay,
Then
yeah, I'm thinking something different. Okay, got it. All right, so you're Thaddeus McCray,
Yes, ma'am.
and Mr. McCray is currently on probation for aggravated assault causing serious bodily injury. A motion to revoke has been filed. Obviously, the main allegation is the new offense of the alleged murder. And it's my understanding that it has not been indicted yet. What I'm going to do is one more reset on this motion. Mr. Smith, I know it's only been less than a month, I guess. Well, a little over a month. If you'll please get with intake and
I'll try to find a timeline on this.
figure out when, and if you'll let us know that, but I'll do one more reset. But if it's, for some reason, there's some issues, I can't just keep holding this for that. So this will be the kind of the last reset on the motion without some specific information of what's going on that murder case. Okay,
Yes, ma'am.
perfect.
Thank you.
You can go back with the bailiff, sir. Hopefully, soon Ms. Perazo will find out what the status of the murder case is. Once it gets indicted, she'll get all that information. Then we'll see where we go with your cases. Okay? All right, you can go back with the bailiff. See, Mr. Smith, did we lose Mr. Bruce?